Say Kimoto Teresia Wanjiru from TES Kimoto and Company Advocates, one of the advocates for the petitioners. So today we had come in for a ruling where the judge, the petitioners were challenging the empanelment of the judges by the CJ. However, that ruling has been dismissed because the court has ruled that the judge the deputy chief justice had properly constituted the bench. So parties have a right to appeal. However, we have been told to come tomorrow at 9 a.m., whereby there will be the issue of consolidation of other petitions that are similar, and therefore we are hoping that parties are going to have their say so that all the files are consolidated. There will also be a hearing at 2:30 p.m. We are now parties because there are some applications that were raised regarding recusal of the bench, because there are applicants who feel that the bench is not fair or has acted in a way that it's not impartial. Therefore, that application is going to be heard at 2:30 p.m. and all parties have been directed to file their responses. And the issue of service, the court has been very clear on it. Parties go to the e-filing portal and get all the documents required and file their replying affidavits for hearing, ready for hearing at 2:30 p.m. So we are hopeful that the application is going to be heard and a ruling delivered so that we are able to go to the substantive issue, which is the petition. So far, it has to be noted, we've not dealt with the petition, and the conservatory orders are still in place. So until those preliminary issues are sorted, then we still haven't started yet. But they are important because the law provides that each petitioner or applicant is satisfied before the process has commenced. So therefore, we'll still come back here tomorrow at 9 a.m. Thank you. Yes. Yeah. But any party, the law is very clear. If you're dissatisfied with a ruling, you have 14 days. You can rush to the Court of Appeal where you seek redress there. So there are some parties who have expressed wishes that they are going to appeal. As for us, we are going to consult our clients so that they can give us the way forward. If it's an appeal, then we have to move to the Court of Appeal regarding that ruling. But for now, the petitioners, not all petitioners have been able to see a copy of the ruling, which we have requested. And so we are hoping that we are able to see it today so that we are able to get proper instructions on whether to appeal or to proceed with the court. Yes, that's it.
Your Lordship, my lady, may I be placed on record for the second and fourth interested party? And permit me to only indicate the implication of the orders of the empanelment that were issued by the judge who directed the Chief Justice does empanel you. The best of my thinking and knowledge is that the prayer was granted as it is for the empanelment of five judge bench.
Mr. Jiru, yes. We speak from the record. You heard me mention the parties. I said that this file has been empaneled to comprise the Honorable Mr. Justice Eric Ogola, the Honorable Mr. Justice Murima, the Honorable Dr. Judge Freda Mugambi. I think that's very clear. We are only three.
That's correct. But we'll address about that.
That the prayer sought herein must fail. Nonetheless, as indicated in our ruling, there is a pressing need for a clear practice directions regarding the procedure and process for handling virtual and online directions and proceedings. We commend the applicants as this application has illuminated the necessity for such guidelines and made the issue more apparent. As such, we hereby direct the Honorable Deputy Registrar of this Division to transmit a copy of this ruling to the Honorable Chief Justice. Before we conclude, the bench wishes to once again emphasize its unwavering commitment to objective neutrality in this matter. We assure all parties that their right to a fair hearing remains fully safeguarded. The bench, acting in fidelity to its oath of office and in strict adherence to the dictates of the Constitution, remains resolutely committed to the fair and just determination of the issues before it. Finally, the application dated 22nd of October 2024 is disallowed with cause in the course. Leave to appeal is hereby granted. Certified copies of these proceedings and rulings shall be availed upon payment of the requisite court fees as the case may be. That's the ruling of the court.
Much obliged, my lord. But on behalf of the petitioners, we have listened to the ruling. We have got no problem with the feasibility of it one way or the other. We leave it to our clients, the decision of whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. Be that as it may, I believe since we received some communications from the Deputy Registrar, and there were certain other pending matters in the files that were under consideration, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether Afisins as Mayane Senior from Rabomwite has anything to add.
My lords, your ladyship, we appreciate that this honorable court of its own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair thing.